Yeah. Hi, everyone. So I'm going to present a report that DAKSH had released last month in August, and which is basically about cause lists. I don't want to presume that everybody knows what cause lists are. So cause lists are basically these documents that are released by courts to inform all stakeholders involved on what are cases that are about to be listed in court. So there are obviously various times at which these lists are released, which are also discussed in detail in the report. On that, these vary. They could come the day before, they could come a week in advance, they could come the day of the hearing. Basically, it's just like a collection of cases that are to be listed. So you can appear in court, do whatever that is to be required for the hearing. That is what essentially a cause list is. Cause list, when you think generally about the listing problem that all of us talk about, and we know there are a lot of controversies associated to listing reforms that are required, we don't normally think about cause lists because they don't seem like very important things that can bring about a lot of change. But we did think that this was like an essential building block of when you talk about what are listing reforms that are required, because this is a very foundational aspect of how listing happens in courts and how stakeholders, especially just interact with cause lists more. That is what you see on how cases are listed and how your case proceeds. So we thought it was very essential to see how are people accessing courts, which is also very much affected by cause lists themselves and the design and the accessibility of cause lists, and how it is very much connected to listing reforms that all of us are talking about. And other than all the listing issues itself, as I mentioned, there are also various design issues of cause lists, not just like how it looks, how easy it is to access, but also in terms of when is it released and things like that. And in conversations that we had with lawyers and judges and litigants, it's also understood that there is such a pervasive acceptance of issues with cause lists. Like, it is very much accepted by lawyers that, like, of course, I will only hear about my matter the day before and I have to rush at the last minute. Or, of course, it is absolutely okay that I have no idea when my matter will come up, or I have no idea how to plan my day or when I will prepare for my matter. These are so accepted that they didn't feel like it deserved a report or it deserved anyone to like talk about it, even because it is just normal. And it is very much how you plan your day, that you will not be able to plan your day. So which is why we thought it was something that required to be talked about for people to discuss and see what are changes that can be brought about. And also so that we can move towards listing policies as well that can be affected because of cause lists. So while we did this report by, we did a survey that was sent out to people. We also talked to lawyers, we spoke to litigants, we spoke to a few judges, we spoke to legal journalists. And these are the general problems that we saw coming up again and again with stakeholders. And I will just go into detail of each of these issues. A main problem that we find is of late publication. Like I mentioned, there is you will see in the report that we have kind of tried to look at what are the general times in which different courts release cause lists. Generally, that they are quite late, and there are also different kinds of cause lists that are released. So not all courts release cause lists the same way. For instance, the Bombay High Court might have something called the weekly cause list, where they will tell you about a week in advance of most of the matters that are about to be listed. So you have a week to prepare for it. It's not catching you much by surprise. While in other courts, it might be that even on the day of the hearing, like in the Allahabad High Court, there are lawyers who told us that at like 10:30 or 11 in the morning, on the day that your case is listed, the list might come out. Or the same situation in other high courts as well, where you might have, like, most of the matters might come up maybe a day or two in advance. You will have pretty much of an idea of most of your cases, but there is still like a supplementary list or some other list that is released a day before, like let's say at like 11 or 12 the previous night, or even the next day morning at about 10:30 or 11 on the date the case is listed. And why this is difficult is not just because there are a lot of things that have to be done before you can be effectively prepared to argue a case, or if you're a litigant, to be present in court, or to tell your lawyer any instructions in that matter, which takes time. And for you to do it well, you require time, and it has to be done a little bit in advance. For instance, like the lawyer, like if let's say it's like an old matter, you might not even have the files. You might have lost the files. You might have misplaced the files and you need to like locate it. That might take time. Things might have changed considerably in the time that the matter has been listed. You don't have the time to figure out what do you tell the court. You might not be able to locate the client itself, and that all of that takes time. And these are all the administrative tasks. Then there is also the very important task of preparing yourself for the case and, researching or drafting or any filings that are required to be done. So all of this is affected by delayed publication of cause lists. And like I mentioned, there is a variation across courts. But there are courts that have these concepts of an advanced list or a weekly list, where most of your cases are kind of sorted. If they're especially older matters or large volume cases, you will have an idea that these matters are going to be listed. While there are other high courts and the Supreme Court that might not, have this procedure of having an advanced cause list. So, so as I mentioned, it affects the lawyer, it affects the party. The parties might not be able to prepare if they want to be in court. They might not be able to be in court because if you're only finding out the day before, and especially, and the study, mainly, we've only looked at high courts and the Supreme Court because it's just very different in the district court. So for ease of the study, we've looked at the high court, all the high courts and the Supreme Court. So for people to get to the High Court or the Supreme Court, it does take a considerable amount of time and preparation. So, which is why another effect of delayed publication, other than it affecting the lawyers, is also the parties themselves might not be able to effectively participate in the hearings. And it also has serious financial implications as well, right? Because last minute you have to then get a lawyer. If there's a senior in the matter, they might not really have time. It takes away time from you being able to brief the lawyer on the matter. All of these implications are there. The suggestion that we've made in the report is that these advance lists could be standardized, that all courts could release these in advance. Like, it's not very difficult really. In most of the larger matters, you will the court registry will have an idea of the workload on that specific day, or there might be a date given, or in a non-date given. It's not very difficult to find out from us having spoken to registry officials as well, that it's not very difficult for them to figure this out. So, and there is really no response coming from them as to what is the issue really, as to why it's not happening. We've also spoken in certain courts like Karnataka, for instance, where there was a practice of an advance list, which was then stopped. Not sure why. But so basically, the suggestion is that with these advanced lists that come up, the lawyers, litigants, public members, journalists, judges also will just get a little bit more time to prepare for matters and be able to plan their days accordingly. So I've just put together some anecdotes that we've had in the report. You'll find things like this, that if you speak to lawyers or litigants, you will always have them say this, right? Like about cases being missed, or things that might have included like very bad financial implications, you having to like rush last minute back from one high court to the other high court, or you have to have a matter on the Supreme Court. These anecdotes are aplenty, especially with regard to delayed publication. The main issue that generally that lawyers or litigants or anyone faces is the lack of certainty during your day. As I mentioned, it is so pervasive that people don't think twice about it. Lawyers will spend 5-6 hours in court just waiting the whole day without a matter being heard at all, and not really think about it because it's so accepted that that is supposed to be your day, that you're just waiting the whole day, waiting for your matter to come up. Or parties will come, they would have, let's say if you're hearing in the Supreme Court or a High Court, you would have traveled all the way, you would have come there, and you would have waited the whole day, and then your matter won't be taken up. And it's very accepted that, okay, I'll just come back the next week. And yes, there are all these financial implications, there are problems with all this planning and what is the thing that you're wanting in the matter to happen itself, and that is getting delayed, but it is very much accepted. For instance, in the cause list, certainty is of two types, right? Like one is, will your matter get listed at all? That is not the purview of this report. What is in the report is, if it is in the cause list, will it get heard and when will it get heard? So as I mentioned, there is no predictability on that. Like you could be a very experienced lawyer. You could have spent 50 years at the bar and not be able to correctly predict when a matter might be taken up. So the general thing that lawyers do to figure out when will my case be heard or how do I plan my day, especially if you have like multiple cases across different courts, you need to be able to plan your day. And how you might do that now, because there is no other way, is if you will ask the lawyers in the cases before you to ask how long do you think the case might go on for. If it's like a longer matter, how long do you think both counsels will argue, and this is all like a very rough calculation, and you're just trying to survive with that calculation, could completely collapse. It just has to have a judge say, okay, I don't feel like hearing this matter today, or some counsel will have an emergency. No, any of that could happen, and there is just absolutely no certainty. Or if it's like, you might think it's a matter that will be argued for the whole day, and suddenly there might be one thing that the judge wants specific instructions on, and the matter will collapse. So everyone's planning just, collapses around those small things. So because of this, as I mentioned, there is just absolutely no predictability during your day. And when we speak to lawyers, you see this having multiple impacts. Like one, you're just not able to get to multiple courts. There are many lawyers who told us that they've had to really restrict their practice because they have no predictability to be able to go to, like, let's say a district court or a high court or the Supreme Court all on the same day. So they've had to very much like restrict their practice. Or lawyers who are trying to branch out from the district court to the high court, they're not able to again and again make that travel from like a district court to the high court, have both matters not be heard. So they then restrict themselves to the district court where they feel like they have more predictability over their day. We also spoke to women lawyers who are very much affected by this lack of certainty because they're not able to then manage their childcare around it. They're not able to be like, okay, at lunchtime, I will be able to go home. I will, take care of my child, or any other like parent caring responsibilities, because you might just have a matter that is then coming up at 2 o'clock and you will not be able to leave the court. We also spoke to lawyers who told us that women lawyers who told us that because of this, along with delayed publication and uncertainty, even women lawyers in law firms who told us that they were reaching a level of where they thought that they would make partner, but then childbirth happened, and along with uncertainty and this delayed publication of causeless, they had to take up matters of lesser stake, where they knew that even if something happened and the day was so uncertain, that it would be okay. And that meant that they lost the position of becoming a partner at a law firm. We also spoke to a lawyer in Rajasthan who told us about this lack of uncertainty having like life-threatening implications, where there was an intercaste couple and there was a protection order that he had to seek before the High Court. And he spent the whole day waiting outside the High Court with the couple in his car. He put his driver in the car and waited with them. So because they were very worried that family members would hurt them outside, and the matter didn't come up. So then he had to spend a whole other day driving this couple around parts of like Jaipur for the hearing the next day. And like there was no mentioning that was allowed by the court. So there could have been a very bad like life-threatening implication for this lack of certainty. This also affects government officials who have to travel to court. In the Supreme Court or the High Court, even if their presence is not actually asked for, they might just turn up in court to assist the lawyer who's arguing, or the lawyer might have asked for certain documents, so they will come. And this also involves, like I said, coupled with the delayed publication, it would very much have been that, they would have had to take a train or a flight like the day before, they would have spent the whole day in court. We spoke to a government official who told us that there was like a public hearing that was supposed to be attended by around 3,000 people that was set up in the district that he works in. And the previous night at 11 o'clock, the Advocate General called him from the High Court saying, oh, this matter might be listed tomorrow. It's still not in the cause list, but we expect that the matter will come up. And this man says, but it's not in the cause list. Why should I travel? I have a public hearing tomorrow. 3,000 people have been invited. I can't give that up. But the AG says, no, you have to come in case you do not turn up. And in case the matter is just listed in the morning's cause list, there could be contempt action against you. So this man is forced to leave the public hearing. All these people who've been called, God knows what happened to them. And he travels to the High Court immediately. And the next day waits till about 12 o'clock. The cause list is not out. And he thinks, okay, now the matter is definitely not going to reach. I might as well head back. Starts to head back. Half an hour later, there's a cause list that is released at 12:30, listing his matter at 3:30. So you can imagine the kind of unpredictability that is caused due to the way that these listing procedures is done through cause lists in courts. Like I said, so there are many like detrimental effects, right? Financial stress that is caused, lack of predictability, threat in the case of like, let's say if you have like an interim order that is about to run out on a day, and there is let's say there's like a demolition that is ordered to be stayed only till like a particular day. And there is so much uncertainty over whether your case will be taken up that day, because there's just so much workload the judge already has. And if you don't think that the case can be mentioned out of turn, there is a lot of stress that is caused if you have, in the case of an interim order. And we did speak to a lawyer who told us that the judge was in such a foul mood that day that he didn't even allow for a mentioning to happen out of turn, that a demolition happened because the interim protection had passed out, a demolition of a building happened. And as I mentioned, outstation lawyers and litigants who are not, who have to travel to get to the High Court and the Supreme Court are also affected because of the lack of planning and financial implications that it has. One of the suggestions that we've made in the report to be able to figure this out a little better is that you could have case management hearings in court, which, like for instance, in the Supreme Court, there are already registrars who are whose only job is to get a case administratively ready for hearing. So they could also do that, them along with maybe the judges, probably not in the Supreme Court because they might not have time for it, but the registrars really could sit and try to figure out how much time will a matter take. This is also a suggestion that's been made by the Law Commission about pre-listing hearings, that there should be pre-listing hearings to kind of find out how much time will each party take. This is specifically in terms of like longer final hearing matters, to just see how many cases should be listed in a day so that all cases can be effectively heard instead of just listing matters randomly. Like for instance, in the Supreme Court the other day, before a bench, there were 300 matters that were listed. There is no way any of those matters were heard. Finally, on that day, just 2 matters were heard out of 300 in the cause list, where parties would have turned up, but just 2 matters were heard. So if cause lists don't then just go ahead with listing all matters that are supposed to be listed that day, but to list matters that can be effectively heard and maybe a couple of extra matters. Then there's also a practice in the Supreme Court that could maybe emulate it, which is in the before the vacation starts, the court releases a possible list of cases that they want to dispose of or they want to hear. I mean, that's just randomly decided by the judges and the registry. It might be picked up from older cases that they want to dispose of, or cases of like importance that they want to deal with. And a list is sent out, and then lawyers are free to say, okay, do we want to argue this matter? Yes, we do. And then a time is like a slot is given. And they're also kind of told to tell the court master as to how much time they will take. So this practice then kind of streamlines the amount of cases that are heard in a day, and everybody will also then be able to get effective disposal or hearing of their matters. Another thing that can also be considered, which is case complexity, along with looking at what you figure out from lawyers on how much time they will take to argue. You can also look at the kind of complexity of individual case types and then see how long it might take and do case management accordingly. Another problem that we've heard about is a lack of clarity over the purpose or the stage of hearing. In many high courts now, as we record in the report, you will see that the cause list divides the kind of cases into stage of hearing. So it will tell you if it's like an admission hearing, if it's a final hearing. So those kind of give you a little bit more predictability over how long a case might take. Like, admission hearing will barely take about whatever, like with the Supreme Court, will barely take 30 seconds or like a minute. While if it's a final hearing matter, you will then proceed to ask people how long will they take to argue the matter. But in many courts, that's not there. And if the stage of hearing or the purpose of hearing for the matter were to be included in the cause list, it would really improve the predictability of matters and also help all parties prepare for the matter accordingly. Another issue is the ambiguity of lists. This again is very much more of a high court problem than a Supreme Court problem in terms of multiple lists. The Supreme Court really just has like, let's say 3 lists, while there are high courts that have more than 10 or 12 lists. I mean, again, there's a considerable variation across high courts. There are some high courts that will have about 10 or 12 different types of lists, while other high courts might have 4 or 5. The problem with the chronology issue really is no one really knows in what order the different lists will be taken up. It's not really ever mentioned in the cause list, other than the only place where we've seen this mentioned in the cause list is the Chhattisgarh High Court. Otherwise, the cause list or the website really will not mention the order in which the different lists will be taken up. Like, let's say you have a terminal list, you have a supplementary list, you have a 1401 list, you have a 909 list. which like this is there in some high courts where we've asked lawyers, like, what do these lists mean? And even lawyers don't know, like lawyers who practice there for 10 years don't know the difference between like a 909 list and a 1401 list. They just know that this judge has this kind of list. So yeah, so again, the way in which a list is taken up is also very judge specific. So unless you are someone who's practicing there, you also might not know that day what the order in which the list will be taken up. But imagine how difficult it is for like an outstation lawyer or like a young lawyer without a clerk or any real resources to figure all this out. The only way is for you to go and ask the court master. But the court master also might not really tell you because they also don't want to commit to it, because it ultimately just depends on how the judge wants to take up his list on that particular day. We've recently seen, after the publication of the report really, that the Supreme Court has started to do this sequencing where, and this is easier for them because they don't have so many lists. They just have that one or two lists where it will be mentioned on the Supreme Court display board. They will mention the sequence in which the items will be taken up. Like for instance, if there's 1 to 100 matters, and if the judge has made up his mind, or if it is part of like an earlier order, that some matters will be taken up out of turn. Like it's not going to go chronologically like 1 to 100. The sequence will then say, okay, we will take up 50 to 57 first, then it will go back to 14 to 18, or like then we will come back to 90 to 97, right? Like this is mentioned. So in the Supreme Court, at least, that's a little easier to find out. You don't have to go to the court master and ask them what is the sequence for that day, which is absolutely not there in other high courts, where you are then left with like 7 lists and you have no idea in what order they're going to be taken up. Like you can see here that in this court, that there is a supplementary list, a lunch motion list, a daily list, and others. There's a separate list 1, separate list 5. And all of these are the different kind of lists in which the order of which you don't know for that day. So you don't know what case is going to be taken up in what order. Another that is just how inaccessible cause lists are in terms of being able to read everything together and make sense of it. Like all of these are issues that just lead to you either missing out a matter, you will be delayed for a matter, or just not being able to figure out what is happening. Like there might be a very specific, like there might be a notice saying that this matter is not to be heard today, but it is not a part of the cause list. It will be on, as in it'll be a part maybe somewhere in the cause list, but it won't be next to your matter, or it won't be in the same place where your court, all the other matters in the same courtroom are mentioned. So unless you go through, let's say, this 1000-page document, you will not be able to find one. Usually lawyers are just like using Control F and looking for their case number or their case name. So unless the instruction for that specific matter is not next to that matter or in the courtroom's list, you will probably just end up missing it. Or it could also just be on the court website on some location. So in case, I mean, by practice, of course, local lawyers will kind of know what to look out for and what not to miss. But if you are an outstation lawyer, if you're a litigant, if you are, let's say, a journalist or like just a public member who wants to find out what's happening in that court, you will not be able to find out. And there are also times when these instructions are extremely difficult. Like the other day, we had a case where there were 3 lawyers on the case and none of us were able to figure out what the order was or what was going to happen in court that day. Because their instructions were something like, okay, these matters will be taken up if it's a 3-judge bench sitting together. These will be taken up if the 2 judges not sitting. But in case the 3 judges sitting, these are the items that will be taken up. And the sequence was very odd. And it was also wrong because the matters that were listed before the 2 judges were all 3-judge bench matters. And everything that was listed before 2 judges were 3-judge bench matters. So there was just utter confusion, which could have been simply avoided by the instructions in the cause list just being given all at the same place. Another thing that we found with lawyers is how much easier it would have been for them to coordinate with lawyers on the other side for, let's say, just for a hearing, if you want to pass on submissions, if you want to, let's say, take an adjournment and you need them also in court to appear along with you, if their contact information is to be made available along with the cause list. Of course, there is a problem of privacy, but we spoke to lawyers in Delhi where this is already done. And they've told us that they've actually not had much of an issue with that, and that they much rather prefer having the names of those lawyers on the cause list. And another problem is where in the cause list, Usually what's happened, as you can see in the slide, is only the first petitioner or the first respondent is going to be marked, and they will always be and others or and another. It would be helpful if in the cause list, if all parties could be mentioned. There's of course a problem that there are matters where there are 50 or 60 respondents, and that's going to take up, of course, a lot of space. A workaround around this is what we've seen in the Madhya Pradesh High Court, where they have a simple like a hover option, where if you hover, you will get all the party names. Or there's like a collapsible option, where in the first instance, you will only see the first petitioner and the respondent, but then if you press on it, it will just expand to all parties. This will help technological improvement. Like for instance, let's say like something like a provokil. If you don't have a case number and if you want to search by party name, or if you don't have any of those also, if you just want to Control F and find with your party name, you will not be able to find with party if you're not the first petitioner or the respondent. We've also spoken to government lawyers who told us that this would be very helpful, where if you're representing a state entity, or if you're representing a state, where you might be like respond number 26, 27, and it might be that you're just searching for your name. And in case this is there in one of the parties, then it is very helpful. Because how it works with government offices also, lawyers are assigned to these matters, and they have such volume that till the day of the hearing, they might not even really know that the matter is assigned to them. So if it is a part of the cause list, they can again just search in the cause list and find this out. Another main issue that we found, especially from not just disabled lawyers, but disabled litigants as well, is the fact of how cause lists are very inaccessible. A main problem is many websites have CAPTCHA, where if the audio is not clear, it is usually very distorted. In options where there is audio, usually it's just visual. Many of the high courts will say that we have accessible websites, but they're absolutely not accessible. It just says that it is screen reader friendly. But what you need to do to make it screen reader friendly is that you have to work in the back end such that screen readers can read it easily and comprehensively. How it is done now in most courts is they will make it screen reader accessible, but the way that it is done in the back end is that there will be same things on the same line. So the screen reader is not able to read it accurately and will read multiple things at the same time, making it very difficult for the person to understand. And even there are many like hover over options, which also are very difficult. And the many options in which the documents are available, like PDF is not very accessible for screen readers. HTML and other OCR formats will obviously work better. The last one is the non-availability of cause lists for technological solutions. So as I mentioned, there are usually the formats in which cause lists are made available are in PDF or some in HTML. But if it was to be, and I think there's only 2 high courts that make it available in the Excel format. Our suggestion is to make it available in .csv, as we've spoken to people working in Provokil and Legistify, who also said that their work would be made much more easier if it was to be made available in more accessible formats like CSV, where all of this work around cause lists can be made easier, and it will also lead to data accuracy and completeness. A main problem with, as I mentioned again earlier, with all the cause lists is because the data is just available at multiple levels. It's not in one place. Like if a matter is listed as item 3 in court 2 on a particular day, if there's a small note next to it saying this is to be taken up along with so-and-so, it is very likely that something like a Provokil, which is supposed to give you notifications on everything related to your matter, will miss it. So the experience, like I've been using Provokil for nearly, I think, 6-7 years now. And even now, there is not complete accuracy. I mean, they're doing a great job, all of them. But the problem is that because of the issue in the way that the websites themselves are designed and the cause lists are designed, it is inevitable that there will be things that are missed out. Like if there's a specific instruction that's given by the court, or if there is a notice that is given that is not a part of the cause list, but a part of the website, they will not pick it up. So you still have to do the job of going through the cause list yourself every day manually and seeing if there's been anything that's missed out. And all of these are things that can be fixed by the court by bringing in better design and just better thought into how information is placed throughout the website. So in the report, we've also gone through, we've tried to collate best practices that are brought up in many courts. I will not take time to go through each of them. But basically what we found is things like this, right? Where case status and the is linked. So you can easily access by just pressing like this hyperlink. It will take you to the case status from the cause list itself. Or recently what the Supreme Court has done is something like a live display board. It's not completely there yet, but it's definitely better than earlier, where you can see what is happening in your case at that time. Otherwise, what you have to do is you have to either go to the court physically, or you have to look at the live streaming link to figure out what is happening, or you ask another lawyer. But now here, you can see at what is the case detail and what is something and the result that has happened in that case. So yeah, these are all the best practices that we've kind of found out from in the report. And we've also collated best practices that are followed in international courts. Based on all of this, we have made an ideal cost list or a model cost list that is available on our website. We created like a prototype of what a good cost list could look like and what are different components that could be there. This is available on the DAKSH website. And these are things like the date and time of generation of a cost list. This is very much integral to accountability and transparency of court proceedings, because we have also seen earlier that there's very much a possibility that a cost list is released, and when there is a certain controversy or an issue, the cost list could just be removed and a new cost list would be replaced on the website. So having things like the time of generation or like a timestamp of generation on the cost list really helps with issues like that. And it also, if you have a certain time of generation, it also increases predictability, where people are able to know, okay, this is kind of around the same time that these cost lists are released on a weekly basis or a daily basis. And if I'll just go through some bigger suggestions in this. If you look at number 9, there is a time at which a particular case or type of case is to be taken up, is a way to increase predictability of court hearings. Like I said, it might be very difficult for courts to say, okay, this is the exact time at which I will hear a case. Workarounds around that, until you work up to that, is things like slotting. And this has been attempted by courts before, where they will have a morning slot or an evening slot. And they will say, okay, the first 50 cases will be taken up in the morning slot. So then whoever is in the afternoon slot, they don't have to wait during the morning in court. They can do anything else or attend to other matters. And they know that there is no way that their matters will come before the evening. Or there was this practice in the Supreme Court for some time that was tried by a few judges, where they would have smaller slots. Like they would say, okay, from 10:30 to 12, we will finish these matters. And there is no way that even if they finished all their matters, let's say at 11:30 instead of 12, that matters that are supposed to start at 12 will be taken up. So again, you have more predictability of when your matter will be taken up, and you only have to wait in court for those particular slots. So until the court is able to get to a time when you are able to have very good case management, that you know, okay, I will only list these many cases in a day and I will only take up at exact time. These are smaller measures that can be tried in courts, and they have been tried in courts before, in High Court, Supreme Court, and the district courts, and it has worked. Other things could be something like a composite cause list, which would solve the problem of multiple lists and the sequence in which matters could be heard. So let's say in a High Court, there are 7 lists that are to be taken up. The judge could simply tell the registry the previous day that this is the order in which I want to take these different lists. And the registry can release a composite cause list, the order in which these different lists are to be heard on the next day, so that there is more knowledge on all sides on the order in which the list will be taken up. Yeah. And one is on 21 is on responsible lawyers to be marked in case of government litigation. What happens in a lot of these government matters is a reason they get adjourned a lot, anecdotally again, is on the reason that they will turn up. There might be 30 state entities who are appearing, and they will say, okay, only one person has to file a reply, which is why none of us have filed a reply today, because we don't know who had to file a reply. One way that this can be avoided is if in the cause list itself, the judge can ask on the day of the hearing, who's a lawyer who will be responsible. I mean, there actually just could be one state party who has to give a reply for the matter to be effectively heard. If that can be marked in the cause list itself, that would help probably reduce any delay at the time of hearing. So each of these suggestions, about 24 that we've made about components of a model cause list, are all part of our model cause list page that's on the website. And all of these are clearly marked on the website itself. If anyone wants to go through the different components, there is also a tour functionality that has been added on the website to take you through each of these components that are in the model cause list.
We only have 10 minutes left for today's seminar, so
yeah, sure. Sure. Yeah, I'm just wrapping up. So quickly, for implementation of these suggestions, the major problem is that judges and other administrative staff in the courts face a lot of like administrative inertia, right? It is very difficult. Like there are many things that we told them, this is very easy to implement, but there is a lot of inertia in wanting to implement these issues, in suggestions like this, for trying to find out the time of hearing or making changes to the time of publication or things like that. That might seem very intuitively easy for us, but there is a lot of administrative inertia that comes around with this. And that is to be thought of and worked through. And the standardization of nomenclature across courts is again something that courts will always push back against, specifically High Court, because they're all autonomous bodies and they don't want the same sort of systems to be followed across different courts, is what we see. And even though they know that there are practices that have been in those courts for the last 50 years that have not worked, there is very much an inertia to move away from those systems. Another issue is the lack of comprehensive listing rules across courts. So none of these things that I have mentioned are in most of the rules. There are very few high courts that will have rules on when will a cause list be released, or what will a cause list contain, what sort of matters are to be included in the cause list on a particular day. These are all just what people know from practice. So there is a real need to be working towards listing policies that cover all of this comprehensively, and that there should be accountability measures for how it is to be followed. I would like to end with like a short anecdote to just talk about how important cause lists are and how much effect it does have on daily functioning of lawyers and litigants. Just a few days ago, we had a matter that was item 120. So we didn't think that the matter would ever be listed. So we happily sent our senior off to another high court to argue a matter, and we said no need to come back. The day before, in the supplementary list at like 11 p.m., a supplementary list is released saying that there's a possibility indicating that that the matter might be heard. And this man had to take like a midnight flight back, came back. And in the morning cause list, again, a supplementary notice is released saying, oh, we've changed our mind. This matter might not be taken up. It's still item 120. But then the client is already so stressed. The client has traveled along with who are 3 seniors in the matter, all being paid quite considerable amounts of money. They're all being paid for just waiting in court. The client has flown in. We wait till about 1 o'clock and we realize that the matter will not reach because the matter before us will be argued for the whole day. So we go to the judge and we simply mention the matter, which is out of turn you're mentioning and saying, my lords, the matter may not reach. Can you please discharge the board? Discharging a board is simply to say that the other matters will not be taken up. Or can you indicate that this matter will not be taken up? And the judge says, yes, I'm aware that the matter before you might take till 4 o'clock, till the end of the court, but you wait. He could have very well said, he's also aware that the matters will not reach, but he says, okay, you wait. So the lawyers who are being paid enormous amounts of money and the client continue to wait for another 2.5 hours till 4 o'clock. Around 3:55, 5 minutes before the court has to rise, we all leave thinking there is no way that the matter will now be heard. And we walk out of court. 5 minutes later, we get a call from court saying that matter immediately has collapsed. There is about 2 minutes left, about 3:58, 2 minutes left for the court to rise, and your matter might be taken up now. And that is something that was out of any of our control. Couldn't have been planned in any way. And we had to quickly, just appear on VC and simply a date was given. The matter was not heard. This was something that the judge could have done very well before lunchtime. There was nothing stopping him. So all of these are issues, I want to say, are kind of worked into the psyche of judges and administration that even when suggestions, workable suggestions, like discharging a board early, if you know that a case is definitely not going to be heard, you don't want to make people wait. Those are suggestions that are still a little difficult to push with the judiciary. So any of these suggestions are things that will take time, especially because of how differently each of the courts function, but are definitely things that we should push towards to help with just the mental health of lawyers and clients and financial implications that people have, to make the process of accessing justice just easier. Yeah, let's stop. Thank you.